our title today, Are Your Affairs in Order? And so I think everyone knows what we mean by affairs. Papers is kind of wonderful things that we need, but we might not exactly know how to go about that. So in our families, could be a lot of changes, and something's always changing in the family. You have a baby being born, you have someone who may pass away, you have a marriage of yourself or other people in your family. You may have strong feelings one way or the other about the person who your relative has chosen to marry. And all of a sudden, there's a lot of changes in the family dynamics. And so it's always a good idea to look into the future, although it's kind of hard sometimes for us. But we need to concern ourselves with a couple of things. While you're alive, if you were to have a head injury or have, God forbid, go into a coma and not come out, or go into a coma that was 6 months and then you came out, what happens to your money for the 6 months? And what happens to your healthcare decisions while you're out of it? Like I said, coma, head injury, dementia, other temporarily or permanently cannot make a healthcare decision. So I just want to let you know I've got a healthcare proxy on the table. If you've never signed one, they're free. I use a free Commonwealth of Massachusetts form, and which my own doctor has given to me. So it's a very generic form, but to Massachusetts, because it follows what the laws are in Massachusetts. Here, you appoint a person who you trust and have faith in to make a healthcare decision for you. You're alive, but cannot make the decision. Other states may have other ways of doing it. I have heard people ask me about something called the 5 wishes, which is all very good and is a tool of communication where you discuss what are your wishes if you had a medical emergency, and you discuss it with your relatives. But the law is that the doctor wants to know who's the name on the form and what's their phone number. And so that's why your form is not a long drawn out thing, and it doesn't say any detailed information. We used to, when I was a new attorney, we would write these 6-page healthcare proxies. Then as time went on, things got more complicated, and I realized there's no doctor that's going to sit there and read your 6 pages. They want to know, I have to cut Mary's big toe off, and she can't sign, so who am I going to get permission to do this operation? That's kind of a simple example. So as you know, with healthcare, they're doing more. People are staying alive longer. You get a head injury. 30, 40 years ago, people used to die. So now they're alive. And so what is the best thing for them? And your best option to start this off is to have a discussion with the person that you think is the one you want to make the decision for you. The form leaves a space for an alternate, and you're going to try to think about person number 2. In case person number 1 can't do it, doesn't want to, whatever, moves to England or something like that. Second thing, which I mentioned, was money, which is those same reasons: head injury, incompetence, temporarily or permanently, cannot make a financial decision. This is a broad power. The document's called Durable Power of Attorney. My advice is everyone over 18 should have one. It's kind of like car insurance. You hope you never need it, but you are sure glad when you have it. So same thing, you appoint a person number one who you have faith in and they're gonna do right by you with your financial decisions, and you appoint person number two. You keep the document in your home and you tell person number one where it is in case something happens to you. You do not put it in a safe deposit box because only you can get into the safe deposit box. So those are the things while you're alive. The other side of that is when you're no longer with us. So if you died tonight, would your relatives know what you wanted for the distribution, passing out of your assets? That is everything. Cash, checks, savings, stocks, bonds, CD, real estate, 401k, etc., etc., etc. Possessions, especially valuable ones such as cars, boats, jewelry. So those are things that you address in a document called a will, which people probably have heard of. Last will and testament. In Massachusetts, your will cannot be, handwritten. So it's best to have a lawyer do your will for you because there's intricacies in the law that you want to make sure are addressed. And I've had people ask me about internet wills, which is, I do not agree that that's a good option for people. One example is this. If you have children under 18 or grandchildren that you want to leave something to, if you leave it to them in your will, then at the probate court, when your will goes through the system of the probate system, the judge has to appoint a guardian ad litem over every beneficiary of your will who's under 18 or who is disabled. So you don't want to, that costs a lot of money and it's a hassle and it takes a lot of time. So it would be better if you gave your funds to that person's parent or guardian on their behalf. So that's just one example of how I'm trying to point out that internet wills are lacking in a lot of areas, let's say it that way. Okay, so your will, what goes through your will is those things that are in your name alone. For example, if you own a house with another person and the deed says, well, first of all, if you're married, the deed is going to say tenants by the entirety. That means when one person passes away, the other one is automatically the owner of the real estate. If you have a car that's in your name and your name alone and you pass away, the Commonwealth of Mass has made it easy for spouses to, if you get a diagnosis where they say you're not going to be driving that motorcycle anymore, you might want to give it away. Or, if you need the money, obviously you can sell it. But just if you know somebody wants it, the time to give away your treasured possessions that you want to know where it's going is while you're alive. So if you can make a way to do that. So I didn't tell you, I guess the worst news I have for you is if you don't do those documents that I said at the beginning, the healthcare proxy and the power of attorney, but you're still alive, a hospital or rehab center is going to be forced to go to the probate court and get a guardian for you. Now, your relatives may come forward and say, oh, I'll take that job of being the guardian. But the decision is up to the judge. And so It's very complicated. The last one I did took 9 months and cost a lot of money. The person, sick person or incapacitated person, receives a free lawyer paid by the Commonwealth of Massachusetts. So if there's any question about whether they're competent, some of the time, whatever, that lawyer is not going to allow the court to appoint a full guardian, which you may think your relative needs. So going backwards, rewinding here, let's avoid all that. What happens with your estate at the probate court while you're alive. You can avoid them being involved in your business, the government being too involved in our business. You have control over that if you take advantage of the opportunity and think about it, which I'm very glad that you're all here today, so that means to me that you've been thinking about it. Okay, same thing with the power of attorney. If you don't have one and you have real estate in your name alone and you're alive, no one can sign a deed and sell the real estate if that has to be done for whatever reason. You're never going back to your house, whatever. You need a power of attorney or a conservator. Same thing, a lot of money, a lot of lawyers, and the judge decides who the conservator is. So you can avoid all that by the document called durable power of attorney. If you don't have a will, the Commonwealth of Mass does not get your money. That's a myth I hear all the time. They do tell you who will get your money. So they have a family tree it's called the Uniform Probate Code, and they tell you who will get your money. And it may or may not be someone you want to get your money. And I'll give some examples. So in the family tree the Commonwealth of Mass has made for us, spouses get 100% or mostly everything, depending on if there's children from a prior marriage or second marriage, third marriage, whatever. So the spouse has a strong inheritance right in Massachusetts. If there's no spouse, the kids are next. Say you have 4 kids. One is a surgeon, and they have no children, and you put them through medical school. And then you have another child who has 3 of your grandchildren. Who do you think would need your money more? Maybe, probably, the one with the grandchildren. However, the Commonwealth of Mass says, no, you have 4 kids, you've got to divide by 4. And they all get the same equally. Another example, if one of your children has their health insurance from Mass Health, you probably know there's a limitation on what dollar amount they can have for assets. And they cannot have more than $2,000. So if they inherit from you $50,000, they are going to lose their eligibility for Mass Health, and you will be causing them a lot of issues with their medical care and red tape if you leave them money and they're not entitled to it. And there's not very much ways to manipulate this. Like, say there's a house to be sold. And so I'm just throwing out even numbers here. Like, say the house is $400,000, and you have 4 kids, and you're going to give them $100,000 each. So one could say, the Mass Health person is not allowed to say, no, I don't want the money. And the lawyer who's writing the checks for that real estate is not allowed to write checks to bypass the rules here. So this is how it is. And you know, the government has rules and ways of checking on these things. Now, if you have $20,000 in the closet in the bedroom, whoever finds it can pass out the $20,000 in cash to anybody they want. But when you're dealing with checks that come from a bank account and are going into a bank account, there's a public record that the banking system is aware of, And they're going to know that the person on Mass Health got this 50,000 or whatever number. So when you see, maybe people don't know this, but when people sign up for Mass Health or that's not Social Security Disability, SSI, which is a program for poor people who have never worked, you give them permission to look at your bank account. So a lot of people that I talk to, because I have done some of that work, don't seem to realize that when they signed on, and it's very clear, there's a statement right there, but people don't read things, that's the other thing. Well, I shouldn't say everybody, but many don't read them. And so they don't know, oh, the government can look at my bank account? If you're on Mass Health, the answer is yes. And so you would need to know that when you're doing your plan for who's gonna get my stuff and my money after I pass away. So, part of this is, it's a kind act not to leave a mess for your relatives. And, you know, we all know there's conflicts everywhere and conflicts in families, but you have to put that aside and say, okay, now here I am, I'm in my right mind right now, what am I gonna do and who am I gonna have faith in to make these decisions? And so, between family, friends, children, grandchildren, nieces, nephews, whoever, think about who you have, and very rare, but sometimes people hire a lawyer to do that job for them in their lifetime. They don't have any family, or the family's all passed away. Occasionally that happens. But it's very rare. Most of the time, the control should be with the family of of those assets. And most people can find at least one person that they have some faith in. So I've said a lot, and just take one more second here. So I've talked about some of the changes that happen in families that kind of force you to think about these things. So I guess my message just would be, think about it before you get forced into it by a medical emergency. And because if you don't come to from the medical emergency, then somebody else is going to be making decisions that belong to you. So let me hear from you for questions. Yes?
All right, I'm kind of a little different. I don't have a lot of anything, okay? My kids aren't much help. I can put their name down. But how do I, like, I've got the will, my daughter helped me get that together. I just have to have it notarized. She works for a lawyer, so I can do that. But as far as assets, I really don't have anything. I just want to make sure everything's done, like the apartment's cleared out, I paid for my funeral.
Well, if you read your will, there's a magic sentence, but I'm concerned what you're talking about, though.
Okay, I need
Because
help is what I'm
did a
doing.
lawyer write your will?
My daughter did, she's a paralegal.
Okay, because you'll see there's a magic sentence, all the rest, residue, and remainder of everything I own, I give to
Anybody in the family.
whatever
Whoever needs it.
name you said. Your will has that. Let me just say,
Yeah.
if it's a will that's
Right.
done
I've got that
correctly,
in there.
it has that. And so you don't need to worry about who's cleaning out your apartment.
Well, I
It's the
do as
person
far
you
as
appointed.
being rental, you know.
But you need to tell your executor, which is now called personal representative.
Right, okay. Oh, okay.
You need to tell somebody.
Yeah, well, she's my everything.
So they're gonna take care of it.
I hope.
Well, no, the law says they're gonna take care of it. If they don't want the job, they tell the court, no, I don't want the job, and person number 2, who you should have an alternate executor in your will, they'll take care of it. Like, that should not be a concern. Because even if those 2 people said no, someone else in the family is gonna go to the court and say, I'll be the executor.
Yeah, because she's on the will, she's on the power of attorney, she's on everything. that
Yeah,
have.
I guess I'm not clear on,
Well, I got.
Why you're
well, what
concerned,
it
'cause
is
you
is
said you did it.
I'm still in the dark on certain things, yeah.
I guess I would say, read your will again, and then talk to your daughter. And then the other thing, your will is a useless piece of paper
Okay,
unless it is signed in the presence of 3 witnesses, one of which must be a notary public.
okay.
Okay,
So
so,
I didn't realize that, okay.
and they should all, in ideal setting,
Right.
they need to be all in the room at the same time.
Yeah.
Okay, so
Can
many
they be
people who do
relatives?
the internet wills, and they show them to me and
No.
I say, okay, where's the signatures?
This isn't the internet, this is right from the,
Right, but the will is a useless piece of paper
right,
unless it is signed in the correct way
right, I got that.
by, like, it can't be signed by someone who's named in the will, for
Correct.
example. And one of them should be a notary
Oh,
public.
yeah, she did tell me that,
So you have to take care of the signing ceremony, which is part of what, if a lawyer does your will, they're going to do it according to the way the rules work, so. Okay, other comments, yes.
One of my questions, I think you just answered.
yeah.
A personal representative is the same as an executive?
Yes, in 2012, the law changed in Massachusetts, and there was many things that changed. Some of the wordings changed. The biggest change was the spousal inheritance was strengthened. But the other change was it's now called personal representative. Okay, so but on TV, you watch Perry Mason and all these old shows, older shows, that say, oh, executor, okay.
Yeah.
So that's why.
I do have an internet will, but I did have the 3 witnesses.
Okay,
And one of the witnesses was a notary republic. My question is, here it says where the notary, says my commission expires, and it gives a date.
that has to do with their commission. In other words, they can't sign after that date. So it has nothing to do with you. You're
So
fine.
this is still legal
Yes.
or whatever afterwards?
Yes,
Okay, because it
Yeah.
ends this year, and I was like,
right. Oh, no.
I
'Cause
didn't know if
you-
I had to renew it or.
We get a notary commission for 7 years. And then we have to renew the person who's the notary has to renew their commission.
Okay.
Yeah, so you should be fine with that.
I know we didn't talk about this yet, but is a DNR, that has to be renewed or whatever the fuck?
DNR, I think you're referring to do not resuscitate,
Yes,
which is in the law. And the only time, I've seen them a couple times, if you have someone in the house on hospice, you put it on the refrigerator or that they
It
don't
doesn't have to be.
want to be resuscitated. And then, or if you're in a nursing home and they know you're at end of life, or you've already had 5 heart attacks and you're 95, then you can sign the form. Mark the X, do not resuscitate me. So the decision for a do not resuscitate is very individual and depends on the person and the doctor.
I already had that, but I didn't know if it needed to be kept up or renewed or whatever.
Well, you have it in advance of your illness, because you're here today.
Yeah.
So I think when you get to be in that mental state, or you go to a facility, they're gonna ask you the question over again. And a lot of the facilities have their own form. So there's no renewing, it's,
Okay.
you don't need it at this
You can
moment.
change it though.
Of course you, absolutely, if you're competent.
That was a
That's
good.
what I thought.
So if you're competent, you can change it.
Right.
If you're incompetent, your healthcare proxy is going to fill that out.
Now, can your healthcare proxy be the same as your personal representative?
Yes,
Okay.
yes,
Thank you very much.
Question?
yes.
Dumb question. Durable. Let's say durable power of attorney.
Okay, so that means it lasts. Or you can, say you have surgery and you're out for 3 months. Incompetent for 3 months because you're on too many drugs, whatever. Then it comes back and you get your power back. In other words, it doesn't end or go away. Oh, I gotta get a new power of attorney now because they used it when I was in the hospital last year. No,
So the durable is temporary or permanent?
no, permanent,
Permanent, okay. As opposed to- okay.
yes.
One owner's name on a house,
Yes,
Can that be written in a will that, say, the kids are to sell it and split proceeds, or?
the law says they're to sell it and split proceeds.
Okay.
If you want something else done, like you wanna let somebody live there, like say you had a disabled child, I want them to live there for at least 5 years after I die. You leave them a life estate in your will. Or you could do it on the deed before you pass away.
Yeah.
You could write a new deed that says I give my house to my 3 kids, but I want Mary to live there for 5 years after my death, if she wants to. In other words, she would sign, say she wants to move out after 3 years, and then they can sell it and everybody gets their money. Long as you understand the other people are gonna be waiting for their money.
Yeah.
If you did this life estate thing. So that's like a gift, you're giving them a right. You're not giving them any money, you're giving her the right to live there.
Now, if you have children, some are very financially capable, and say a couple, say you got 4, 2 are fine, they manage money fine, and the other ones burns a hole in their pocket. So you wouldn't do 50-50.
Well, that's an example of a question that is a personal decision on your part.
Okay.
You do what you want.
You can set up like a trust.
I mean, unless they're incompetent.
No.
Or, whatever, hospitalized or whatever. But otherwise, you do what you want, and you hope they have the right resources. Or you say, I'm only gonna give them 10% each,
Yeah.
and the other people can get it. And just understanding what that's gonna do to the family dynamics
Mhm.
when you do something like that. So, yes,
I had a will and all these papers done like 20 years ago.
yes.
Things have changed. Do I have to go back and notify the original attorney that did that? The
No,
will, the healthcare and all that?
no, the
It's
only thing
just
that matters
one-
is the current.
All right,
And if you're doing a new will, most lawyers would have you rip up the old one right in the office when you sign the new one,
Okay.
because it's not good to leave 2 wills lying around. Think about the reason why. Oh, I cut out Johnny Jones, okay, so now they're gonna be mad, right?
Right.
So yeah, but just because 20 years has gone by is not a reason. The reason is somebody,
everything's
Gone.
changed.
everything's
yeah.
changed. So then, yeah, you need to rethink
Well,
that.
what's the difference between a trust and a will then?
Okay, so a trust, try to give it simple. A trust is like a box. You put things in it to not hide it, but prevent the probate court, the nursing home, who could get those assets from getting them. We're talking about nursing home, you have to make the box, the trust, 5 years before you're going to ask Mass Health to pay your bill in the nursing home.
I heard 7, but it's 5, okay.
Okay, so you can put your house into the trust, but here's the part so there's, second of all, you really need to talk to somebody or read more about trusts. But just briefly, there's 2 kinds of trust, revocable, in the big picture, let's say, there's all kinds of trusts, but in the big picture, there's revocable. Revoke, can get it back. You put the house in, take the house out. You put the house in and 5 years goes by and you wanna get a roof. Oh, I need a home equity loan. The bank's not gonna give you a loan. They will loan to individuals, not to the trust. So you have to take the house out of the trust, just for that, get your bank loan, and put the house back in the trust. So there's some effort involved, and you would need to think about that before you did the trust. So, but the other one that we just started briefly on the topic of nursing homes is called irrevocable trust. You don't want your house to be attached by the nursing home. You think you're going there. You're pretty sure you're gonna run out of money to pay privately. So this is not a hard and fast rule, but I'm gonna say briefly, the first 100 days on Medicare for people over 65, for the first 100 days, Medicare and your health insurance, what other other health insurance you have, pays the bill as long as you're getting better. When, say you stop getting better at day 50, they're gonna come to you and the family and say, there's nothing more we can do for you. You need to go home or you need to go on private pay. So if you don't have the 13,000 a month for the private pay bill, then you're gonna, or if you run out of money, you can go on Mass Health. But if you have a house, well, again, it's more complicated than that. If you're married, you're allowed to have a house, because you have a community spouse, someone who's living in the community, and they need a house to live in. But if you're single, you don't need a house, because the nursing home says, hey, you're too sick, you need nursing care for the rest of your life. And you don't have a house that you need. And so your house is subject to being attached after you die. Not while you're alive, but after you die. So those are just, and it happens in different ways. Some people, their relatives say, oh, why don't you just sell the house? And then you take the cash and you pay your bill till you run out of money, which hopefully is not, it's kind of rare that people stay in nursing homes that long. A lot of people, you probably know, these days there's more home care, even Mass Health wants you to have home care instead of sitting in a nursing home. So there's more care in the home. You probably know of a lot of home care agencies. It's kind of a big business. And you might not need 24 hours of nursing care. Maybe you need 3 or 4 hours a day, which is far cheaper if you had some cash to pay for than is your bill for 13,000 plus a month. That's around here. Other places or parts of the country are different prices. So anyway, I've said a lot, but you can look into it. The internet has a lot of articles, and the website mass.gov has a lot of articles about Mass Health, nursing homes, what their rules are. It's quite an informative from the Commonwealth of Massachusetts. And so that would just be something we could look into. I didn't say, before I forget to say it, there's a couple of articles on the table if you want them, and there is also a healthcare proxy form if anybody wants one. You don't need a lawyer, you don't need a notary, you need 2 witnesses, not the people you are selecting to do the job for you.
Do you need files anywhere?
You should give it to your primary care doctor and any other doctor, like say you have a heart condition, you should give it to the heart doctor, just to make sure they know. And of course, you always keep a copy for yourself.
No, of course.
Okay, anything else? Yes,
On the paperwork you gave us, I see where it says executor or alternate executor. Is it possible to have 2 people? I want co-executor.
it's possible to have 2 people. I personally advise against it,
Why is
because
that?
guess what happens when the 2 people don't agree on the decision?
Nothing gets done.
Right, or they argue and you have all this hatred and bitterness. So the whole point of this is hopefully to eliminate bad feelings in the family. Although they might be mad at you, but you won't be here, so it doesn't matter if they're mad at you or don't like your decision. I did it once for 2 sisters, and they took care of their parents for several years as co-guardians. And then the parents both passed away well into their 90s. But every time that a check, oh, I need to pay this bill. One lived about 50 miles away. The checkbook's got 2 names on it, 2 signatures. Can't have an ATM card on a conservator account or an estate account. You can't make it, there's no simplicity. So one had to send the other one the check. Here, you gotta sign your name. 2 signers on the check. Of course, the other person took their time and then made the other one mad because they were doing all the work, running around buying clothes for the person, et cetera, et cetera. So I'm saying, when this was all over, the 2 sisters didn't talk to each other. So I'm telling you that because it's a bad idea. So, but at the end of the day, you're free to write that 2 people are gonna be your executor and 2 people are gonna be your,
Are you saying now I should have the executor put on like a checking account and stuff?
no,
No?
because you're alive now.
Alright.
Totally different thing. After you pass away, the executor has to open an estate account for your assets
Alright.
that were left in your name alone. Okay, so I guess I'm trying to, say, it's not possible to plan everything, but as I said, the older you get, you should at least have at the bank payable upon death, some sort of beneficiary. And I do understand from a couple people I've talked to recently, some banks refuse to let you put a beneficiary on a CD. I don't know why, and I don't know which banks these are. But you have to ask your bank, if you're a single person and you have a checking account in your name alone, then you should have a payable upon death person on the account that is gonna be the owner of the money. They're not gonna pay your bills, they have no obligation to pay. You are making them a gift,
Oh,
okay? They don't have to pay for your funeral, they don't have to pay for anything. You put their name on the account. They might do what you suggest.
just so they can get their hands on it.
You're gonna get the money. Because say you have a house and
Can
it's
you have
gonna
a
keep.
charity? And, cause my kids will fight, yeah.
I'm sorry, I missed
Can
that.
you have a charity? Have it go to a charity or something,
No,
or?
no, that has nothing to do with the question.
Okay.
Well, you can leave money to charity in the will, but what I'm saying is if you have, the bank's probably not gonna let you leave your money to charity in the.
Okay.
Yeah, I'm pretty sure don't allow that kind of thing. Anyway, because after death, if you leave money to a charity, the Attorney General of the Commonwealth of Mass has to be notified and just, make sure they're really a non-profit organization is kind of an extra step that has to be taken. I'm sorry, I lost my thought, but I was thrown off by the charity.
You were
Do
saying,
you still have a question? Yeah? Okay.
Okay.
Okay, what I was saying is that, we were on payable upon death. I'm going around in circles, sorry about that. So payable upon death, the reason you want them to get the money is that in an ideal world, they know that several months is gonna go by. We gotta put the house for sale. Well, it's January, nobody's gonna buy now. Well, somebody's gotta pay the property taxes, and somebody's gotta pay the electric bill on this house, and heat the place for the winter. So where's the money coming from? And if you have this person who's already taking some responsibility and you trust them enough that you put their name as payable upon death, what they can do is pay the property taxes, and later when the house sells, they can get their money back. Because you have allowed them to have use of the money, by giving them this gift. So what I'm saying is that if you know you got a bad diagnosis, leave several thousand if you possibly can, where someone can get at it. Because they are gonna have some expenses. Either that or they've put it, and I have had this happen, they put the funeral on a credit card. And then when the house sells and 5 months later, they get their $6,000 or however much the funeral costs, money back. So at the closing, before anybody gets, like there's 4 kids, before anybody gets their money back, the ones who were paying the property tax and paid the funeral, paid whatever, after death, bills after death, the person gets paid back. I mean, that's fair, right? So the executor is gonna be in charge of that.
Does being a
Yes.
co-signer on their checking account circumvent that? Like is,
Being a
Yeah.
co-signer is the same thing as a payable upon death. Well, not exactly the same thing. Co-signer, they get the money. It's their money. You die, it's their money. But if they use that money to keep everybody happy, I'm gonna pay the property taxes, then I'll get paid back but they'll say, well, what about that money that you got? And you say, legally, that's my money. I don't have to pay the property taxes. Now, it depends on the family, because many people don't think like that. and they just say, oh, yes, that's what Dad wanted, I'm gonna pay the property taxes. With my own money that Dad gifted you by putting your name on the account. The other thing about, it's moderately dangerous, depending on your family circumstances. Again, every family's different. When you have a person's name on your bank account, that's not the same as payable upon death. Co-owner means you could walk in the bank anytime and withdraw all the money. And maybe Dad doesn't know that, or it says, oh no, they'd never do that, or whatever. But it's moderately dangerous to do that. So again, all families, this is what I'm trying to say. All families are different, you make decisions for different reasons. You know, some people are single by themselves, don't have any relatives. Some people have 5 relatives who are gonna be chomping at the bit to get their money. Or you have one relative who's, I don't wanna say, but an addict. You gotta make provision for people like that. You can't sign over a house to a person who's an addict and think that they're gonna willingly divide up all the profits, and you have to use your wisdom. So the best thing is think about these decisions and make a plan. Get a trusted person in the family. If you want to speak with someone, make some plans in order to get these things done. On my end, I will just tell you, because I'm not sure if people have to go or whatever, how we wrap this up. I'm happy to stay, but just letting you know that I work all over Western Mass, and I'm happy to meet you or whatever needs to be done for you. I'm just letting you know that I'm a person who travels, and there are many lawyers who do travel now and go to people, and I am one of those attorneys. Yes.
I have a question. If you have.
Oh,
I'm
sorry, I thought I was talking to her.
Oh, sorry.
Yeah,
Yeah, I wanted to get some input from you. I had made up a will, and I have no husband, no siblings.
you made up a will with a lawyer or by yourself?
No, with a lawyer.
Okay,
But the question came up after it was drafted.
okay,
No spouse, no siblings. I have 2 children, adult children. So everything was going to be 50-50.
yes,
And then he said to me, well, what happens if one of them predeceases you?
right. Then you have to say, does the other one get the 100%? Or do they
They're
have
both
children?
married.
Do they have children?
Yeah. One does, one doesn't.
Okay, so you have to say what's gonna happen.
Yeah.
And that's your choice.
So the question is, does it go to the spouse, or you can actually skip to the next generation, so it only goes to the children?
You choose. And if I was you, I'd be putting a name in there. You have a right to choose.
Whose name? What do you mean?
Who do you want to get the money? So the question is, somebody dies who you've left as a beneficiary. It's always good to say, if so-and-so dies before me, then Johnny gets it, Mary gets it. My friend down the street who helped me all my life gets it. Could be anybody.
Well, I'm thinking about the bad feeling that might happen if I decide I want to bypass the spouses and leave it to the children.
But you're dead.
And I,
Yes,
Don't
I'm
worry about
good
the
with
dead thing.
I was gonna say, you won't be here.
Let them fight it out. Remember that.
But you should make sure you're not leaving it to children under 18, going back to what I said earlier. Okay, so that's your decision now. Okay, go ahead in the booth.
Yeah, my question is, if you have everything jointly owned, your house, all of your assets, your life insurance, obviously, that's the beneficiary's named in the life insurance policy kind of
Right.
thing. So if you get everything into joint assets and you have a will, when the first person dies, do you still have to probate that will?
No,
Oh, okay.
no, it's after,
It's after.
because
the-
everything is settled.
Right,
by the
so,
law, like your deed, it's in two names. So
right.
the law says the other person's automatically.
So if you
gone.
get everything
Yeah,
100%
there's no
first,
court, no judge, no probate.
so it's not till the second person.
It's not till, right, once there's an asset that somebody cannot get a hold of. Example, you have a bank account that you forgot about from 10 years ago that has money in it, and you can't get it, and your heirs can't get it because it's not included. Then they look and say, okay, who did they leave things to in their will? Or if there's no will, then it's by the family tree, whatever the Commonwealth says.
Thank you.
Okay, any other comments, questions? Yes?
Just to go back, you said a trust, you said, 5 years for the mass health protection. Is that, the, irrevocable trust and, does the person have to live for 5 years? Like, if it was mine, do I have to live for 5 years?
Well,
That was
yes,
fine.
because the reason you're protected from nursing home is because you're afraid you might go there.
Yeah.
So you would be alive to go to the nursing
So
home.
what if it happened in, 3 years?
Like a year after she went to the
Yeah.
nursing home.
Well, then you're not protected.
Okay.
Yeah, see, the protection starts at 5 years. It seems unfortunate, even 4.5 years. So you have to pay your bill for the 6 months, and then you'll be protected. But you have no money, that's why you're applying for Mass Health, so it's a very sticky situation,
Okay.
so.
If you don't mind me asking.
Yes.
Approximately how much does it cost to establish a trust? And are there different costs because it might be complicated?
I would say it's all over the map,
Okay,
and the lawyer that's gonna do it for you, you need to ask them.
okay.
What about the will,
Same
like an
thing.
average cost?
Prices are all over the map, depends on who you're talking to. Yeah. Yes,
What happens at probate? When your will is probated, what happens?
okay, so, probate, you have about 20 forms. You have to list out the family tree, you have to list out
You don't
who's the
know
money
the
left
family
to in the
tree.
will. You have to submit the original will. And there's, as I said, lots of other forms that you're usually filed by the executor who's been appointed in your will. Okay, if there's no will, then some family member has to say, oh, well, they own this house by themselves, we've gotta get this settled. And they go to court and say, I'd like to become the executor. Before they do that, I say, ask your relatives, are they gonna oppose you? Because if somebody opposes you, you'll be there for a long time and a lot of money. So you should say among the family, hey, there's no will, but I'd like to go to the court and try to settle this, will you people back me up, brothers and sisters, or whoever they, cousins, whoever they are. So then you do your forms. There's gonna be a required newspaper publication, probably 30 to 45 days. Then if everything's in order, the judge will say, oh yeah, okay, I see, this is all in order, and they appoint you. If somebody, and then you have power. You can hire a realtor, sell the house, have a tag sale. You have the authority, which a piece of paper you get is called letters of authority. And you have you take that to the bank and you set up your new bank account. The estate of Mary who died. Okay, and so that's everything, any money you get in for the estate or bill you pay. Like say Mary owed the Mercy Hospital some money. You're gonna wait till the money gets in there, obviously, and you're gonna write a check for whatever Mary owed. Her bills while she was alive, not anybody else's bills. And then you're gonna have to show an accounting. As time goes on, you're gonna have a realtor, they're gonna sell whatever. Or you can sell it to a family member, but you know, the lawyer will be writing a new deed, and there's gonna be a accounting required, usually if there's real estate, as to what did you do with all the money, and or if Mass Health is owed some money. These people are gonna come forward because one of the,
They don't want their
especially,
money back.
especially Mass Health is gonna
Yeah.
come forward. And there are people like collection agencies that watch the filings at the probate court, it's public record, and they say, oh, they owe us 20,000 in Visa, and they'll be sending mail to the executor. And if you have money, you should be paying the bills. If you have money and you have a house, you will not be, if it's Mass Health, you will not be allowed to sell the house. Mass Health gets paid person number one at the closing. Okay, except for, I should qualify, the mortgage is first. Mass Health is
So
next.
whatever Mass Health paid you for,
Right, whatever their bill it was in the nursing home that they paid, or your health care, if you were over 55 and you were on Mass Health, they're gonna be settling that up. If you own real estate in your name alone when you die, that you haven't already given away.
but a will bypass probate, right?
No, the will goes to probate.
Oh.
Will does not buy.
If you have a will, approximately how long will it stay in probate? Or how long does probate take
If
if
no
you
one
have a will?
protests,
Yeah.
you can probably get appointed in 30 to 60 days. If there's any question, issue, there's little things that can happen. I had one recently. Cause of death, when you die alone, gonna do an autopsy. The death certificate says cause of death pending. That's gonna hold up your case in the probate court. Gotta have a cause of death. It's a long story, it's related to murder and making sure that no one who murdered the person is getting assets from it, etc. It's like a little funky thing in the law.
It could be years.
Anyway, so the word pending is a problem. And you have to keep haunting the funeral home. Hey, you gotta give me that death certificate. Because like I have one right now. The case is being held up, everything's at a standstill. Because we're waiting for the cause of death. So that's what happens when people die by themselves. And there's a question as to what did they die of? What's the reason they died? Yes?
Yes, do you recommend a revocable living trust to prevent probate?
The answer, the question is, would I recommend a revocable living trust to avoid probate? The answer is it depends on the family, depends on what's in the trust, depends on if you've got somebody to be the trustee. All of these things. It seems like lawyers have these ways of avoiding the question, but the answer is different for every person and every family. If I said to you, oh, you should have an irrevocable living trust, well, I'd have to hopefully have had a long talk with you and had to hear about all your relatives and the money and who's doing what and who needs the money and what are you doing. We would have this long conversation. So the answer is different for everyone. It does avoid probate.
Oh, that's what I meant, trustability.
Yeah.
Does avoid probate?
So you have to decide, does the cost outweigh the benefit you get? So, because when you put your real estate into trust, you have to appoint a trustee. It can be you, revocable living trust, but there's no nursing home protection.
Yeah, no nursing home protection, but avoid.
You avoid probate, right.
That's about it, everything else.
So you have to discuss it with, you should discuss it with an attorney, what is your wishes and why do you want to do it that way?
Can you clarify going to probate? I thought everything has to go through probate. It could be, so the trust does not?
Well, let's go with the verb go.
Okay,
You don't go anywhere.
well, it goes through,
The case goes to probate,
okay.
usually by a lawyer, because as I mentioned, the 20 pages of forms and people don't want to, the forms are moderately technical and the answers can be wrong and when logically you would think it was right. Anyway, that's why people hire attorneys to get that done. So you have to go to probate if there's something you cannot get to, bank account with no beneficiary, life insurance with no beneficiary, or somebody died who they had as a beneficiary and they didn't get around to putting a new beneficiary. 401k, oh, I forgot to put somebody's name as the new beneficiary. This happened to my uncle, he got divorced. He didn't put his son's name on the beneficiary, he left his ex-wife as the beneficiary, who got all the life insurance money. So these things happen when you.
And there's nothing he could do once she got everything, right?
Well, then life insurance and these accounts pass by a contract with Fidelity or Prudential or whoever they are, they have to give the money to the one that you said is your beneficiary. It has nothing to do with your will, so it's a contract, as opposed to the will goes through the probate court and only affects, like say in your will it says, I leave my Corvette to Mary. But the year before you die, you gave the Corvette to me. There's no reason to go to probate. You've already decided, or you're out of money. And it says, I leave my bank account at TD Bank. Well, you don't have a bank account at TD Bank because you spent all the money. So there's no reason to go to probate. So we go to probate, meaning
Okay.
file at probate, if you have assets that no one can get to. If you go in the bank and say, hey, I'm the executor on this will, and they say, oh, okay, you gotta go through probate,
Cause your name's not on it, yeah.
because your name's not on the account. And so you need to be officially become the executor, we're not just gonna give you the money. That's why I said way back, put a payable upon
I was
death.
gonna say, that would save you, yeah.
You won't have to go anywhere, you just walk in the bank with your photo ID and a death certificate. And you'll get the money, payable upon death.
So will, no will, trust. Do those cases go to probate regardless, and it's just a matter of, it gets probate process. If you have a will, it's 30 to 60 days. If you don't have a will, it could be
It'll be a little longer,
Yeah.
but you'll get appointed as the executor without a will, as long as no one in the family is protesting.
okay.
So
But even if you have a
objecting.
will, it still goes to probate
Yes,
because probate is a process.
yes, and
That
because
has
there's
to be-
real,
Yeah.
the probate is for things in the dead person's name alone. Otherwise, you don't have to go to probate. If you have a house, it's in two people's names, there's no probate. The other person gets it. That's if it's tenants by the entirety or joint tenants. Once in a great while, the parent will say, I'm leaving it to the 4 kids, tenants in common, 25% apiece, while they're alive. So while they're alive, so then the parent dies, and these 4 people only own a 1/4 share, all separate. So you have to sell it and prove that doesn't go to probate, but they still only split 4 ways. So that's one way to do it, because they did the deed while they were alive. So you can sign your deed while you're alive, but there's tax consequences, which is another long story that you should ask your accountant. Hey, if I receive $100,000 out of a house while the person is still alive, I receive this gift of a house, but I can't get it till they die, there's tax consequences. So you have to ask your accountant, or whoever, tax preparer, somebody who knows something about taxes.
If someone contests a will or contests, that can go on for years, correct?
Correct. So that's why it's good to sit with people and say, and occasionally if there's like no will, people say, oh, can we meet with, if you can have a meeting with a lawyer who will tell you, here's what's gonna happen. I hope you don't object, because otherwise you'll be here for a long time and many thousands of dollars, more than you need to pay. Is there anybody who would like to be the executor? And hopefully they've discussed it, or I'll say, okay, well, why don't you think about it, and I'll go away and call me when you're ready.
That's a question.
Yes,
Both are related to the local living trust. So the first one will be, let's forget for the moment about nursing homes and waiting 5 years.
yeah,
In which case, the local living trust is not advisable to do over a will. And the second one is a revocable living trust done. For how long Massachusetts, for example, allow that to be enforced?
okay, question number 1 is a question for you and a lawyer. The answer is different for every person. Whether a trust is right for you is something you're gonna discuss with the lawyer. You're gonna see, what are you putting in the trust? Because if you only put your house in a trust and you have all this other money, you're still gonna have to have a will and have other ways of distributing the money after your death. Okay, and so that's why I'm saying, when you're talking about trusts, you have to understand you and the lawyer need to understand, what do you want to do? You want to avoid this, you want this to happen for this child or grandchild?
It's a seamless transition from, to the inheritance, the children. It's a seamless transition to the children.
Yes, and that's your call. On the trust, you're gonna have dates.
Yeah.
I don't want these kids to get this money till they're 30.
Correct.
You can put that in if you want.
For now,
As long as there is a law about, hundreds of years, you can't carry it out, I have seen trusts where it's carried several generations, but somebody is managing that like a bank that manages trusts, which charges fees every year, meaning there's a lot of money in there, and they only wanna give out, $20,000 a year to somebody. Yeah, somebody's gotta manage that, and it's expensive.
so as long as somebody manage that, then the duration of the local living trust would be,
It can be someone in the family,
and it could be for.
or it could be a stock fund manager, if you have enough money. So there's rules about that. These companies have their own rules about how much the stock fund has to be worth before they would be involved in managing a trust. And not all stock companies manage trusts. You have to find somebody to do it. A lot of banks have people like that. So listen, I'm gonna finish it up. Last question.
Okay, just checking. Does Massachusetts still allow the, no contest clause? Like anyone who contests this will shall not take under it
Yes.
tax clause?
Yes,
They're still usable?
yes. Okay, so let me say thank you and happy to chat with you. I've got some cards and things